conversation that we're having this morning. My name is Dan Onofrio. I'm with the Bridgeport Regional Business Council. And for those of you who may not be familiar with us, we are a regional business organization consisting of 3 chambers: the Bridgeport, Trumbull, and Stratford Chambers of Commerce. And in addition, we have many affiliate programs, whether you're talking about leadership and workforce development or economic development. We also have the Bridgeport Economic Development Corporation that works in conjunction with the city of Bridgeport. So we do all things business at the Business Council. So thank you for joining us. As you can imagine, there's a lot of anxiety as we head into next week as we reopen part of the economy in this first phase. One of the things we've been getting a lot of calls and emails about are regards to the legal obligations of some of our employers and what they're responsible for as it relates to their employees. So we're happy to have Cohen and Wolf here and Stuart Katz, both of which have been wonderful supporters and partners of ours right here in Bridgeport, Connecticut. So we're happy to have Stuart here to speak a little bit more detail about some of the things you can expect as a business owner or employer within your organizations. So with that, I'm just going to do a quick introduction of Stuart, and then I'll turn the mic over to Stuart to get into the details of the program. Just a couple housekeeping things. There is a Q&A feature on the bottom of, you should see it on the bottom of your Zoom web browser. If you have any questions and there's time, we will try to field as many questions as we can once Stuart is finished with his presentation. So Stuart is the only lawyer in Connecticut who has been named Lawyer of the Year by the Best Lawyers in America for representing both management and individuals in the area of employment law. Recognition that reflects his unique experience on both sides of the employer-employee relationship. A strong advocate who brings a strategic big picture approach to every case. Stuart has been recognized in Chambers USA from 2017 for the superb quality of his counsel and representation. Stuart represents employers of all sizes in defending a wide range of discrimination and harassment suits and litigating restrictive covenant breach of contract and wage claims. Stuart also represents professionals and executives in matters related to their employment. He routinely provides workplace trainings and guidance to employers and employees regarding personnel policies, handbooks, and employee discipline. Stuart's employment practice includes representation of clients in both state and federal courts. He regularly handles matters before the Connecticut Commission of Human Rights and Opportunities, the Equal Opportunity Commission, the Department of Labor, and other administrative agencies. Stuart also serves as an arbitrator and mediator for the employment disputes. In addition to chairing Cohen and Wolf's employment and labor and litigation and dispute resolution practice groups, Stuart chairs the firm's Diversity and Inclusion Committee, which has undertaken a number of initiatives aimed at promoting greater diversity and inclusion in the legal field and at Cohen and Wolf. Stuart is a graduate of Brandeis University and Boston University School of Law. So with that, I welcome Stuart Katz of Cohen and Wolf. Thanks, Stuart.
Thank you, Dan. I'm glad I sent you the short version of my bio, but thank you very much for that introduction, and thank you to Dan and to Kate for setting this up this morning. I have been practicing in Bridgeport since 1992, and this is certainly the longest stretch during that period of time where I've actually not set foot in Bridgeport. Like many of you, I've been working remotely, which has been an interesting experience. Up until March of this year, I never considered myself somebody who was particularly good or efficient at working from home, and by necessity, that's changed dramatically over these past couple of months, as a lot of things have in our world. One of the things, as I was listening to Dan very graciously share my bio, one of the things that's changed dramatically is what I do every day. Because the courts have been largely shut down, the state court in particular, there's been very little litigation going on for me this last couple of months, and instead I've spent most of my time presenting webinars like this and counseling clients on a whole host of issues relating to how we deal with our workforce, in the face of this unprecedented situation that's really, engulfed the entire world. As an employment lawyer, it's been fascinating. It's been busy also, but it's been fascinating, dating back, a couple of months, which seems like eons ago, to when Congress was passing new federal legislation, to create this paid sick leave act and to expand family and medical leave for people directly affected by COVID-19. That we're seeing legislation that's being passed by Congress, and before the ink is dry, trying to explain it to clients and interpret it without any body of experience to provide context for the advice that we're giving. So it's been interesting, and it's been challenging because a lot of the guidance has changed so quickly and so frequently. I think I gave a general webinar on the Family First Coronavirus Protection Act, FFCRA. I probably gave a webinar 5 times with basically the same slideshow, and the content was very different each time because new guidance had come out from the Department of Labor. So it's been a challenge. It's been exciting, and candidly, some of what I'm going to talk about here today, will probably change tomorrow and next week because that's the pattern that we've been seeing. But nevertheless, we are where we are. So I hope that this is helpful and informative. Just as I get started, I want to thank Kaylin Mustafa and Jonathan Shahar. Kaylin and Jonathan are law students working for our firm this summer in what is our first virtual summer associate program. There's a very good likelihood they will never set foot in our office, which is an unusual experience for us and certainly for them. But they've been invaluable in helping me put together and try to assimilate and assemble the information that I'm going to talk about here today. So without further ado, I'm going to jump right in. Okay, that's a very, very short version of my bio. It's significant though, because this photo demonstrates that I am not displaying my COVID beard. I actually had a beard before the virus sent everybody home. I also used to wear a tie. So here are the things I'm going to talk about today. I've kind of broken it up into 2 sections. First, I'm going to talk about what reopening really means, and I'm going to drill down into the state guidelines that have been issued both for essential and for non-essential businesses, because I think there's a little bit of confusion about what applies to whom and when. And then at on the other end, I'm going to talk about sort of the specific legal considerations and try to focus on how employers can best try to avoid discrimination claims. I'm going to talk a little bit about paid leave issues that are going to be implicated now that our businesses are reopened or more reopened. And I'm going to talk about some of the pitfalls that may confront us as employers and that hopefully we can avoid. As Dan said, there is a Q&A feature. I've got so many screens going right now that I'm going to probably not look at it while I'm going through the slides, and hopefully have time at the end to cover as many questions as I haven't answered throughout the presentation. So we heard a lot over the last week about the reopening of the state and about guidelines that have been issued and what applies to whom and when. And it is important to understand that the state really didn't close. And what I mean by that is, there was a period of time where it looked like, and I would say back in March, it looked like the state was going to end up being more shut down than it was. But in reality, essential businesses have been open all along. And it's important to understand that because the conditions under which and the requirements under which essential businesses have been open, that's what provides the context for these guidelines that were announced last weekend, which are getting a lot of attention right now. So I'm going to talk about both. I'm going to talk about the safe workplace rules that were released in April for essential businesses and the sector guidelines and the more specific guidelines that have been released over the past week. And it is important to make that distinction. I did look at the registration list, I think, last night, and I can tell because I know some of the people that registered and I'm familiar with a lot of the businesses that we've got a combination of essential and non-essential businesses, at least as defined by the state. And it's going to be important to understand the interplay between the different sets of guidelines. So just as a refresher, on March 22nd, Governor Lamont issued Executive Order 7H, which is one of many executive orders that have been issued. This one was the stay safe, stay home executive order. And that's the actual turning point where non-essential businesses were directed to basically shut down by the end of the day on March 23rd. And what happened after that was that the state issued a kind of a definition of what essential businesses were so that people would know whether their business was essential or not. And that definitional structure ended up being far broader than people anticipated. So that a lot of businesses that thought they were going to have to shut down didn't have to fully shut down. That being said, though, the governor did encourage businesses to move people to remote work, to telecommute where possible, and to try to really eliminate the number of people in the business, in the workplace, ideally to only have essential employees. And I think a lot of businesses did that. And then the state issued what's called safe workplace guidance through the Department of Economic and Community Development. That was issued in certain, it was updated is what I'm trying to say. So what was issued initially sort of expanded. I have the link up for it here, and I am going to make these slides available afterwards. And the safe workplace guidelines that were released in April, were pretty stringent. So just I sort of tried to hit the general points here. So the general points were that all employees who are able to should be working from home. They eliminated all non-essential workplace travel, required procedures to be communicated in other languages as necessary, and really strongly required that access to visitors to workplaces be controlled. Not letting non-essential visitors in, requiring that visitors be interviewed about their travel history and their health condition, and providing hand sanitizer, soap and water, et cetera, for people to wash their hands. In addition, the guidelines mandated that employees have to wear masks. And initially, it was kind of literally a mandate that everybody has to wear masks. And then there were a couple of carve-outs. So if you're working in a private office with the door closed, you can take your mask off. You do need to wear it if you're in common areas of the building. They relaxed the restriction for people who work outdoors, who are not going to come within 6 feet of each other. And the rules did not require that masks be worn by people for whom there would be a medical reason not to wear the mask. But by and large, the instruction here was, if you're at work, you got to wear a mask. And if you're visiting a business, you have to wear a mask. The Safe Workplace Guidelines also required a number of measures to be taken to control or reduce the amount of contact that employees would have with other people. So that would apply to both coworkers, customers, clients, et cetera, requiring everyone to wear masks, creating social distancing, strongly discouraging in-person meetings. The rules essentially say you may be in the same physical office space, but you should still meet remotely if you can. Creating partitions to create distance between people who work very close together. Many businesses, were instructed to provide curbside pickup, stores, and things like that. Really to minimize traffic in any public spaces within the workspace, kitchens, break rooms, et cetera, and also to take a look at ventilation. In addition, the guidelines required that transmission points be eliminated. So keeping doors propped open to the extent possible, frequent cleaning of all common touch points, providing wipes, disinfectants, prohibiting people from using each other's phones, other equipment, asking people to clean their workspace at the beginning and end of shifts. And obviously, if a sick employee was suspected to or confirmed to have COVID, to follow the CDC guidelines for cleaning and disinfecting. So again, these rules have been in place since April for all essential businesses, and I believe that the success of having these rules in place is what laid the groundwork for the governor to decide that we could kind of expand and reopen. I put reopen in air quotes because I think we've been open, but to expand what reopening means in Connecticut starting on May 20th. Just a few other points from the Safe Workplace Guidelines. Employees who are ill should stay home. I don't care if that's essential employee, essential business, non-essential employee, non-essential business. Anybody who's sick should stay home. If you have a temperature over 100.4 degrees, stay home. My mother would say if you have a temperature over 99 degrees, you should probably stay home. But the state of Connecticut says over 100.4. Again, sanitizer, posters that encourage hand hygiene. We've all been hearing constantly since the beginning of March about hand washing. It obviously makes a difference. Apparently you got to wash for at least 20 seconds, sing a song, etc. If you've been exposed to somebody who has COVID or is suspected of having COVID, don't go to work. Notify your supervisor, isolate yourself from the rest of the people in your home, see a doctor, etc. Again, these are all rules that have been in place for the essential businesses in the state of Connecticut since April. Anybody who has the symptoms, again, should notify the supervisor and stay home, follow the CDC recommendations. If you're asymptomatic but have a sick family member, again, what we've been hearing is that you can have the virus and be asymptomatic. So it's important to follow the CDC guidelines in those situations. Now, this is very important. I've had a lot of questions about this over the last month or so. What do you do as an employer if you have an employee who's confirmed to have the virus? These are the highlights of the CDC's rules, but you should inform fellow employees of their possible exposure, but try to maintain confidentiality to the extent possible. Now, depending on the workplace, that attempt to maintain confidentiality, may be more successful than in other workplaces. In some instances, it's going to be pretty obvious, if one person doesn't show up at work and then you inform the coworkers that somebody who shall remain nameless tested positive for the virus. I think everybody's probably going to conclude who that person is. But the point is that there is, under the Americans with Disability Act and similar state laws, obligations to maintain confidentiality, and those should continue to be observed, even where it seems maybe a little silly because it's obvious. Coworkers then have to self-monitor for symptoms. There should be efforts made to ventilate the areas visited by that individual, obviously to clean and disinfect that space, and common rooms and shared equipment. And we've all heard a lot about contact tracing, which is really, if I'm sick, who have I been in contact with, so that those people can be communicated with, and to take precautions. And this is exactly where that comes in, because if you had one worker who tested positive and they work in a room by themselves every day for whatever reason, that person has not come into contact with nearly as many of your other employees. If on the other hand, it's say a manufacturing facility, and the person is working on a floor with others, even if there's been an attempt to maintain some social distancing, there's going to be more people that employee came into contact with, even more so if there's a shared locker room or other common areas. And that's going to inform what has to be cleaned and disinfected and how many people need to be notified. Needless to say, people should not be returning to work until they're cleared. So whatever requirements their physicians have put into place or the CDC requires, everybody should really be striving to not be coming back to work and not be encouraging employees to come back to work until they've been cleared, because that's going to help minimize the spread. So, as I said, these are the rules that have been in place for the essential employers since April. So now, what I think we saw is that the governor, and obviously those people advising the governor, wanted to see what can we do next. So there was this announcement of a plan for reopening, and the question has been, well, what does that mean? And so far, what we know is that the idea is to have 3 phases for reopening. The first phase is going to begin on May 20th. The details about phase 2 and phase 3 will be probably announced next week. overall, I think the Connecticut plan for reopening is consistent with CDC guidance, which I think is what everybody's looking at. But there's a lot of angst about this. And a lot of businesses and consumers are asking, well, are we ready for reopening? And, obviously very subjective. I think that, what's been reported is that we've seen an almost 40% decline in COVID-related hospitalizations. The state of Connecticut's administering something like 42,000 tests per week, and everybody's gotten better at tracking the disease. So there were certain benchmarks that were established that the governor has spoken about, and it was only unless or until those benchmarks were met in terms of reduction of hospital admissions and positive tests, that it was only until those tests were met that this decision to open or to reopen was reached. And I think that we've been cautioned by the governor, by the Department of Economic and Community Development, that this is intended to be a deliberate process. In other words, it's not a flipping of a switch, right? It's not like on May 20th, we're going to press a button and everything goes back to normal. I think business as usual is going to be redefined. I think it doesn't matter what industry, what business we're in, things are going to look different and probably for quite some time. And, part of this is learning how to coexist with the virus since there's no vaccine. And I think that applies equally for us as individuals within our families. It's going to apply to schools and it's going to apply to businesses. Everyone's got to have to figure out how to coexist and how to go about something that approximates normal life while still adhering to what I think a lot of people are going to view to be pretty considerable restrictions. This phase one is expected to, sort of ease in over 4 to 6 weeks. I think what's been articulated by the governor is there are some main goals of phase one. The primary one is to increase consumer confidence by showing that we can open our businesses in a safe way, that people can feel that they're not taking their life into their hands going to visit one of our businesses. And that applies to our employees as well as to our customers and to our clients. I think the goal is to allow this to happen without seeing some sort of unacceptable growth in the transmission of the virus. And that's going to, remain to be seen. Obviously, a lot more people are going to be out and about. No matter how slowly this is phased in, there are going to be more people out and about after May 20th than before May 20th. And the Department of Health and other organizations are going to be tracking rates of transmission. And, we've heard from other places around the world that there have been efforts to reopen and then this necessity of dialing back. So I think we have to be prepared for that. And I think that's what makes adherence to these guidelines for those of us that run businesses. I think it makes adherence to these guidelines crucial because we want to position ourselves, our businesses, our communities to continue a positive trajectory instead of having to slide back. So, I think that's sort of from a public policy perspective, where a lot of this comes from. So one of the questions I'm hearing is, well, which businesses must reopen? We got this big announcement, May 20th, who has to reopen? And the answer is no businesses, right? There is no mandatory aspect to this. There are limitations on which businesses are permitted to reopen, but that doesn't mean that any business must reopen. And it was the same thing with essential businesses all along. Just because you may run an essential business, you were not required to remain open. So, nobody should feel pressure to reopen, frankly, for any reason. One thing we can say with confidence is that if you are one of the types of businesses eligible to reopen, you have to pay very close attention to whatever guidelines have been issued and created for your business. And to that end, over the weekend, the state of Connecticut issued guidelines. A lot of people refer to them as sector guidelines, but guidelines were released that explain exactly what the requirements are for businesses that will be reopening. So when these sector guidelines were released, there was a little bit of confusion about whether or not these only applied to businesses that had literally been closed or whether they applied to all businesses. And the best guidance that we received up until today, at least, is that these guidelines, the ones I'm about to talk about, are actually for the non-essential businesses that were closed down completely. So if you're an essential business and you have been operating, in whatever capacity since the March 23rd executive order, and you've been adhering to the safe workplace guidelines, safe workplace rules that I just went over, you're not additionally subject to these guidelines that were released last week. Now, there is a tremendous amount of overlap between the two. And as you're going to see, these sector guidelines that I'm going to discuss are really an outgrowth of the safe workplace rules. There are a few differences. From a public policy perspective, I'm not entirely sure why they weren't made applicable to everybody, but they haven't been. So, if you notice distinctions, that's true. There are some distinctions. But let me just sort of run through these guidelines. I've included a link, and this link is really worth visiting because they made, it's very user-friendly. Unlike the safe workplace guidelines that I went through earlier, which are very comprehensive, an effort was made, I think, with the guidelines released over the weekend to make them a little more user-friendly. They're actually like presented in a graphic format. I don't want to say it looks like a coloring book, but it kind of looks like a coloring book. But it's very effective, and they do a very good job sort of summarizing what's applicable to all businesses, all non-essential businesses, and what's applicable to the particular sectors that were identified. There's also some additional guidelines supposedly coming soon from an implementation task force that may touch on some of these issues. That could be today, that could be next week, we're not really sure. So some of the general safeguards. There's a capacity limit of 50% for businesses that reopen. Okay, that addresses employees and that addresses customers. So whatever your normal workforce looks like, whatever your normal traffic looks like, you cannot exceed 50%. Now that doesn't mean that on May 20th, you want to necessarily have 50% of your employees back. It would probably be prudent to phase in. I'm aware of some businesses that are going to reopen with no customers and with no clients, just to do sort of some role playing and see how systems and processes are going to work. So that's obviously a good idea. Strict cleaning and disinfection is a protocol that is going to apply in every setting. That's going to apply both before you reopen and then once after you are reopened. Those in high risk groups that we hear a lot about, and those over the age of 65 should continue to stay safe and stay home. That's a suggestion, right? That's not a mandate. The law doesn't say those people have to stay home. I'll talk about that again in a few minutes when we talk about some of the legal areas where you might face exposure as an employer. Face masks, again, should continue to be worn at all times in public, and as I'm about to explain, also in workplaces. And social gatherings should be restricted to a maximum of 5 people. Again, the goal is to keep people socially distanced even as we reopen. So again, the general guidelines are going to require some physical changes. Some of them are going to be just the way you deal with your workspace, and some of them are actually going to require some quasi improvements. So if you have a waiting room in your business, again, every business is different, but if you have a waiting room, you're going to have to either rearrange it or create a dynamic so that people aren't in the waiting room at the same time. I know some physicians' offices, for example, that are spacing out appointments so that people are not going to be in the waiting room at the same time, or having people wait in their cars until it's their time to come in. That kind of, those are the kind of changes that are contemplated. Separation of workstations. Again, it depends upon exactly what your workspace looks like, but if people sit close together, you're going to need to think creatively about ways to separate them. So that's, all of this is going to require some planning. You should look at your ventilation system, talk to your landlord or your HVAC, folks, if you have your own, if you own your own building, just to make sure that your ventilation and circulation is working optimally. and that, you're adhering to whatever guidelines have been promulgated by the CDC about ways to improve ventilation. Contactless equipment, that's going to be easier to achieve in some scenarios than others. If you have copy machines or things like that people need to touch, you're going to need to think about how to do that in a safe way. That may involve providing wipes that people can wipe down equipment, before they use it or after they use it. So the focus on personal safety is paramount. Work from home, WFH. That's still the suggestion, right? Anyone who can work from home should work from home. And again, depending upon your business, you might have a lot of people that can still work from home, and they should, right? There's no compelling reason to bring people into work that don't need to be in the office. For those that are coming in, they need to be wearing masks. Again, you're going to limit the capacity to no more than 50%. You're going to be required to maintain a log. The log is going to tell you who's in the business when and who has been in the business when. And there are two reasons for that. One is to make sure you're staying below 50%. The other is, so if in the unfortunate circumstance that someone gets sick, you're able to identify who they might have come into contact with by knowing who was in the building or who was in the office at the same time. Health checks are going to become a routine, right? Now that's going to mean different things for different people and different businesses. It may simply be requiring people to run through a mental checklist every day that they don't have any symptoms. It could involve temperature checks. I'll talk a little bit more about temperature checks in a few minutes. They're not required though. Let me just say right now, they're not required. PPE, personal protective equipment, in most instances, that's probably just masks, depending on your business. In certain settings, that could include more. That could include gowns and gloves, rather. But you need to think about that, and you need to provide them for your employees. Now, they're able to provide their own as well, but until you have sort of a sufficient supply of PPE, masks to give out to your employees and to give out to your customers or clients, you really are not supposed to be operating your business. Cleaning, I talked about cleaning before opening and on an ongoing basis. To take that one step further, there should be a cleaning log, so that you're tracking how well you're complying with that. You should have hand sanitizing stations. I believe hand sanitizers have become a little bit more widely available, but that's something important that you should set up throughout your workspace. And I wrote chemicals just as a reminder to myself that the chemicals that are used to do your cleaning need to be the right ones, right? The CDC's put out guidelines on which particular disinfectants are appropriate to confront COVID, and you need to make sure that you're using those or your cleaning service is using those. There's supposed to be training in all these guidelines for your employees, and you're supposed to appoint a program administrator, someone who makes sure that employees are trained and that there is signage. There needs to be signage on best practices for cleaning, for hygiene, and for social distancing, and also for certification. I'll explain what I mean by certification in a moment. I put the asterisk at the bottom of the page to show how all of this fits together, right? Because these guidelines are almost entirely incorporated from the Safe Workplace rules that were implemented for essential businesses back in April that I went over earlier. So, it's really because there was success by utilizing those rules, by enforcing those rules for essential businesses, that the state has decided to expand to other businesses and allow them to reopen. So the guidelines issued over the past week are called sector specific. And there are 5 different sets of them. And if you go on that link that I gave you if you go to the link that I showed earlier, there's actually a downloadable PDF for each of these business sectors. The individual PDF handbook includes a lot of general stuff, which I just went through, and also some very specific guidelines for these particular sectors. So I think it's a little funky how they did this. I mean, hair salons, restaurants, museums and zoos, malls and retail, I understand how those are business sectors. I think offices is incredibly broad. And, it's not entirely clear, what offices that applies to. I guess the way they have to look at it is, if you're in an essential business, which would have included, say, for example, law firms or accountants who have been open all along. Yes, we work in offices. These sector-specific guidelines don't technically apply to us because as essential businesses, we've already been subject to the Safe Workplace guidelines. That being said, I would encourage everybody who has an office or who runs their business from an office to at least review these guidelines. There are a couple of enhancements, there are a couple of additional requirements, and there is no reason particularly not to adhere to them. Again, the goal is to increase consumer confidence, or one of the goals is to increase consumer confidence, make employees feel comfortable, and adhering to some of these additional requirements may help accomplish that goal. I'm going to talk sort of very briefly about each of these just to give you a sense of what the guidelines highlight. So for offices, you need to limit the number of visitors. That goes back to the 50% capacity that I talked about. You need to create partitions between people that have workspace in close proximity to one another, and designate one area, for example, for shipping and deliveries. I don't know how well you can see this, but this is a graphic from this guidelines handbook, that I said looks a little bit like a coloring book. There are a lot of these graphics. This is the only one I threw into the slideshow just to give you a sense, but I have to lean in, so I apologize if it looks like I'm getting closer to you. But what it's showing here is, an example of making the hand sanitizer station available at the entrance. Showing social distancing by keeping people outside or restricting elevator capacity, separating work zones and movement between work zones, moving desks around so people are at least 6 feet apart, placing disposable wipes near shared surfaces like printers and desks, and requiring people to wear masks. So, the idea is, I think these graphic depictions are helpful because not that every office looks the same, but they've kind of replicated this for offices and for these other business sectors that I'm talking about. And I think it's very helpful. It's very illustrative, as we say. Hair salons, this has been a source of a lot of controversy, I think, in the industry. I think there are a lot of people who work in this industry that are nervous about this because they're wondering who they're going to be exposed to. So again, if you operate a hair salon, you do not have to reopen, but you are permitted to reopen. By contrast, a nail salon, for example, is not included in phase 1 and not permitted to open. If you have a hair salon that you would like to open, visits are by appointment only. Conversation during your haircut's supposed to be limited because it increases the chance of transmission. I think that's going to be a challenge for some of us. For some people, that's a time for a lot of conversation. And the first guideline that went out said absolutely no blow drying. There was some pushback about that. So now blow drying is permitted as needed. Obviously very subjective. I'm not going to get into that. But this gives you a sort of a sense of what some of the rules are going to be for hair salons. Restaurants, again, I don't want to say these are all controversial, but in some respect they are all controversial. Restaurants right now are not allowed to seat people indoors. So this is kind of all in the context of being serving outdoors, but tables need to be 6 feet apart. No buffets, kitchen workstations can't face each other. That sounds complicated to me. Using only disposable silverware, no reusable menus, single-use condiment packets. As a restaurant operator, these are a lot of things that are going to, unfortunately create costs and can't be done overnight. So these are, things that are going to have to be looked at before people are able to reopen. And it may mean that May 20th is not a feasible time frame to do that. Executive Order 7MM that the governor issued is a kind of a way to fast track the zoning approval that's often required on a local basis to have outdoor seating, because that was raised as an issue. So if you're in that business, you should certainly consult with that executive order for a little bit more insight. Museums and zoos, again, are only allowed to reopen their outdoor facilities. They can't have group tours. Again, the social distancing and things of that nature are supposed to be in place, as well as the capacity rules. Malls and retail stores are allowed to reopen. As you know, grocery stores have been open with a lot of restrictions in place about capacity and the volume of people and checkout procedures and things like that. And because as an essential business, grocery stores, showed some success, that's what's going to enable the retail stores and malls to reopen. But again, it's only going to work if the rules are followed. So for example, stores need to designate an employee that manages traffic flow to make sure that the 50% capacity is not going to be exceeded. Stores need to schedule hand washing breaks, to sanitize cart and basket handles between uses. Consider designating hours for vulnerable populations. A lot of the grocery stores did that. They allowed people 65 and over to come in early in the morning at a designated time. No seating areas, so common areas that we're all familiar with in the mall or in a store, that they don't want people congregating like that. And again, food stations are going to have to be takeout unless they're outdoor restaurants. I mentioned before there's going to be a certification process as part of these guidelines for non-essential businesses that are allowed to reopen. I believe it went live yesterday. This is the website link. What you're going to have to do is, as you're a business owner, is go on, you log on, you have to certify by answering a series of questions that you're adhering to all the requirements. You're going to, I guess, be able to print some sort of badge that indicates that you have met the certification requirements and that you're free to post that sign or that badge on your social media, on your website, and literally on your premises. Again, the idea here is to build consumer confidence, to make our consumers, our friends, our community members, and our employees in particular, comfortable that measures have been taken and that we're all in compliance. Now, in the event that we're not in compliance, the state is requiring that you post clear signage that shows the state hotline, which is 211, for employees and customers to report potential violations of these rules. So, I guess that's a little bit of additional incentive because we do want to make sure we're compliant, but not only that we're compliant, but that we've got records showing the compliance. So, what I would encourage is, whatever industry you're in, take a look at these requirements, create a checklist or take this little handbook that I'm talking about, print it out, check off all the requirements that have been met, put down whatever information you need to demonstrate that you're maintaining a log of visitors, a log of employees, a cleaning log, because if you end up in the unfortunate position of having to defend whether or not you were in compliance, you want to be able to demonstrate that you were. It's also really important, I think, from an employee relations perspective, to communicate to our employees what we're doing, and why we're doing it, so that A, they know it's being done. You can't assume that people know what we're doing. And also so they understand that measures and precautions are being taken for their protection. Okay, so I'm going to shift gears now and talk about some of the more specific legal considerations. Now, obviously, everything I just reviewed are legal requirements, right? You can't reopen if you don't adhere to these rules, whether you're an essential business who has been open or a non-essential business who has not. But then there are going to be some questions like, who comes back? Which employees should come back? And what I would say is, again, prioritize the ones who cannot telework, right? Prioritize the employees who have to perform their jobs on site. If you have people who can work remotely and it's been going okay, let them continue to work remotely. There's no reason not to. As you're deciding who to bring back, though, as always, rely on objective factors. Don't rely on things that might be attributable to being in a protected class, like national origin, race, or age. Don't rely on prior medical history or even favoritism. Think about pre-COVID, right? Think about how you made decisions about employee discipline, employee hiring, employee termination. Being mindful, of course, not to make any decisions based on discriminatory motives. Okay, those rules all still apply. And you need to think about those factors as you decide who to bring back. Presumably, if you were in a position where you had to unfortunately furlough or lay off employees, you went through a decision-making process then too. And again, presumably did so with an eye towards making sure that you're making fair and non-discriminatory decisions. That should always be part of the decision-making process. Now, what if employees resist coming back to work? Okay, if an employee, for example, has childcare obligations and let's say they have not been working for the last couple of months, it hasn't been an issue, right? So now I ask an employee to come back to work, and that employee has a school-age child. All the schools are closed, and that employee, says, well, I can't come back. I've got this childcare obligation. Well, that's what the Emergency Family Medical Leave Expansion Act that went into effect a couple of months ago addresses, right? So this is a law, and it's an entirely other webinar, but just very quickly, this applies to all employers, or all employers with fewer than 500 employees. It doesn't have the same threshold of 50 or 75 employees like the regular FMLA has. And it's also not the same scope. So basically, if you have a school-age child whose school is closed, you are entitled to 12 weeks of paid leave. The first 2 weeks you can get paid in full, and then the remaining 10 weeks you're paid at 2/3 your regular rate to a daily cap, I think, of $200. That's available to all employees unless they have already used FMLA, regular FMLA, within the past year, in which case they're not entitled to another 12 weeks. So if they use the full 12 weeks, it's not available. If they've not used it or they've only used part, it is available. So, that's just the reality of the world right now, which is that people are home taking care of kids. This law was created to provide that relief for them. If you have somebody who goes on this paid leave, you are entitled to a tax credit for the amount that you pay them while they're on leave against your payroll taxes, which is something that I can talk to you more about offline, or I would encourage you to speak with your accountant about. Let's say somebody resists coming back to work because they are of a certain age or they have an underlying medical condition. So there's a subtlety here that's really important. As an employer, you cannot tell somebody you're not allowed to come back to work because you're 65, or you're not allowed to come back to work because you have this health condition. That substitution of judgment is not permitted by law, unless you meet a very high threshold of believing that there's a direct threat to the person's life. And that's a very high standard to meet. So, as you're thinking about who to call back, don't say, all right, well, we're not calling back anybody over 65. It doesn't work that way. You're not allowed to do that. That's going to open you up to an age discrimination claim. On the other hand, if somebody who meets one of these requirements, either by age or because they're in a high risk population, raises the issue with you and, believes that they shouldn't come back to work for their own health reason, that is something that you do need to talk about. I'm going to get to that on the next slide. But again, understand the subtlety here, which is that that conversation's got to be initiated by the employee. You can't mandate that somebody not come back to work. Now, what about somebody who's unable to commute? Let's say they come to work by public transportation, and public transportation's not running at all. Let's hypothetically. That's somebody that you're going to have to think about accommodating. On the other hand, what if someone says, well, I'd rather continue to collect unemployment. I'm doing great. I'm making more money on unemployment because of the federal $600 supplement. I don't want to come back to work. Okay, that's not okay. Once you make an offer of reinstatement to somebody, if they choose not to come back to work, they're supposed to report to the Department of Labor that they were offered reinstatement, and they should not continue to collect unemployment. So, in my view, that is really kind of gaming the system. I don't think it's okay for employees to ask for it, and it's certainly not okay for employers to condone it. Some might say that's unemployment fraud, so I would be very careful with people who say, I'd rather stay on unemployment because I'm making more money. Now, again, if you have COVID or you've been exposed to COVID, based on all the rules I went over earlier, you might not be able to come back to work. So people are going to have to accommodate employees who are sick or who have been exposed, at least for some period of time until they've been cleared for work. If somebody is back at work as an active employee and they become sick, or a family member becomes sick, they are entitled to paid sick leave under the Emergency Paid Sick Leave Act. That's 2 weeks of full pay. You are entitled to ask for some documentation about that, but I just want to remind people that law, which was passed in March, is still in effect. Now, let's say somebody comes to you and says, I don't want to come back but not because I've been exposed, not because I'm in a high risk situation, but I'm just kind of afraid of the virus. I don't want to get sick. What do you do? Those are going to be the tough situations. That's really not a protected basis not to return to work. It's one of the reasons that all these guidelines are in effect. The idea, I think, is that you need to be able to assure, or hopefully you can assure the employee, look, we've taken all these precautions that have been dictated by the state, and we've made the workplace as safe as possible, and that's supposed to be enough to satisfy people. And candidly, it's not going to satisfy everybody. And if you have an employee who refuses to come back to work and is not entitled to any of these protections per se, you may be in a position of having to terminate somebody's employment. And that's an uncomfortable thing, and every case is going to be a little bit different. So I would encourage you to get advice about that. But simply being concerned about working and being concerned about being out and about is not a basis not to come back to work. And I do think that's going to be an issue for some. I'm going to talk sort of quickly about the Americans with Disabilities Act. It's not entirely clear whether or not COVID-19 is a disability under the Americans with Disabilities Act or under the Connecticut anti-discrimination laws that are sort of very similar to the ADA. But let's assume that it would be, or that some of the underlying conditions would be considered disabilities. Are you allowed to ask if someone's experiencing symptoms? Yes, you are. Can employees with underlying health conditions be told to stay home? No. This is what I was alluding to before. Unless that disability poses a direct threat to the person's health, that cannot be eliminated or reduced by a reasonable accommodation. So what is a reasonable accommodation? Well, it's different things for different people, but the point is, if I have a disability and I believe that I can perform my job with a reasonable accommodation, then it's the employer's obligation to provide that reasonable accommodation and to engage in an interactive process with me to work out whether or not what I'm asking for is reasonable. Now, indefinite leave of absence, probably not reasonable. A partition or additional separation between me and a coworker, that might be reasonable. Some opportunity to, not have to touch equipment that other people are touching. That might be reasonable. You might be able to work that out. The key thing is that you have to engage in that process. Can an employee be required to take a COVID-19 test before coming to work? Yes. It needs to be available, which may be a challenge, but it has to be a real test. And that is, in this day and age, that is something that is okay. Other legal considerations, I touched upon the Emergency Family Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. Again, these are the laws that went into effect on a pretty emergent basis back in March. These are federal laws. They apply to every employer with 500 or fewer employees. There are some exemptions for employers that have fewer than 50 employees or fewer than 25. You need to demonstrate, if you're an employer with fewer than 50 employees, for example, you really need to demonstrate a significant financial hardship to deny somebody the Family Medical Leave Expansion Act, that 12 weeks of paid leave. So I would encourage you to talk to your advisors, your lawyers, your accountants about some of this stuff before just assuming that you're exempt. Think about wage and hour laws. If you have hourly employees that are clocking in and out, if you decide to do a temperature check, for example, or have them change their clothes because they've come from another workplace and you just like them to remove any potential transmission points. Generally, putting on your work uniform is not compensable time. It's not something that's on the clock. But in the context of COVID, I think it's much safer to assume that if you're only implementing the rule because of the virus, that it should be on the clock. If you're going to have people fill out a survey every day when they get to work about where they've been and, if they've been exposed to anybody with symptoms, I think that should all be on the clock. If you're going to do temperature checks, again, on the clock. And so let's talk about that. It comes up in the context of workplace privacy. Asking about symptoms, that's okay. Temperature checks, that's okay. I don't know how many employers are actually going to do it. If you're going to check people's temperature, you need to think about what the logistics of that look like. Do you have one thermometer that everybody's using and touching, and how are you cleaning it? Do you have an employee who's designated to take people's temperature, which means that they're getting within 6 feet of every person who walks in the building? You know, I just don't know, given the fact that there's so many other symptoms involved, how effective or how prevalent that's going to be. I think for our employees, it's really essential to encourage people to check their temperature at home before they come to work, and to stay home if they have a fever of 100.4. But you know, actually doing the temperature checks on premises, you're allowed to. I just don't know how prevalent that's going to be. We've been getting questions. Well, can I write this down? Can I write down who we talk to about what? You know, are there HIPAA concerns? Are there privacy concerns? Well, unless you are covered by HIPAA, right, medical professional that's covered by HIPAA, you're not subject to HIPAA. You can maintain a log of people's temperatures, of whether or not people are experiencing symptoms. You should do that in a confidential file. It shouldn't be part of an employee's personnel file. It certainly should be subject to confidentiality and not shared with anybody who doesn't have to see it, but you are allowed to do that. And finally, I just want to touch on unlawful harassment. It's never okay to harass people or discriminate against them based on their race or national origin. There has been an uptick in some of that, unfortunately, given the existence of the pandemic, particularly against Asians and Asian Americans. I do think it's incumbent upon us as employers to reiterate that that's not tolerated and that will not be tolerable, and that actions will be taken pursuant to whatever policy you have if people were to act in that way. That should apply to coworkers, customers, clients, etc. So I ran through that somewhat quickly. I know we got a little bit of a late start. I'll defer to Dan as to whether or not we have time for any questions.
Yeah, I mean, if you're okay answering a few questions here, Stuart, that works for me. We still have a good number of people on the call, so there are some really good questions here. If for any reason, you know, because of timing here, we don't get to your question, we did capture them. And if you have any that you'd like to ask, please utilize the Q&A. We'll get to all of them. If not on this call, we will follow up with you directly with the follow up to some of your questions. So don't think that we're going to miss you. Does that work okay for you, Stuart?
Yeah, no, that's fine. And I think, as I said, I'll make the deck available, and my contact information's on it if anybody needs to reach out to me individually. So let me just take a quick look at these, and I apologize if I go silent while I read.
Yeah, no, it's okay. You want me to throw a few of them at you and make it easier?
Sure, if you've looked at them already, that's fine.
Yeah, I've been monitoring the questions, and like I said, Kate and I have been capturing them. So if we don't get to your question, we will certainly get some kind of response back over to you at some point, you know, in collaboration with Stuart. But one of the things that came up, and we've been actually fielding a few of these calls since the self-certification link was made available yesterday, is, you know, arguably there's businesses that have been closed, and based on this first phase, theoretically, they still should be closed. So one of the holes or loopholes in this whole thing, at least that we've been experiencing, is, you know, if your business was designated to be closed and not considered essential, you know, if you go, it seems like the site is going, you know, allows you to go through the self-certification. And for instance, there's some retail that should still be closed based on the guidelines, but they go through the self-certification and they get the badge, which we've heard they've been able to get. So does that mean that they're okay? Or what, you know, what should be the process? So in fact, I've actually floated that up to DECD to let them know that we're starting to get some questions on that. So what's your take on that, Stuart?
Right. So that's a great example of something that may or may not have been contemplated, but probably needs to be addressed. You know, if you log on to do the self-certification, right, there's no way for the bot or whatever that, you know, computer system is to know who you are, what your business is. So it presumes that you're supposed to be doing the self-certification. I don't think that you can get around the rules on whether you're supposed to be open or not. So, you know, if, for example, you know, you run a nail salon, which there's been a lot of discussion about the distinction between nail salons and hair salons, you know, and you go in and self-certify, I don't think that makes it okay just because you're able to get the badge. On the other hand, I think if you're an essential business that has been open all along, you're not obligated to do the self-certification, but if you choose to do so, you can. right? So because the portal's open to everybody, not just the non-essential businesses that have been permitted to open, right? So it's open to people on all ends of the spectrum.
Yep. Thank you. Can you clarify what the guidelines on the age? Is it 60 or 65? I think we've heard both.
I've seen 65. Again, it's a little tricky because you can't sort of impose upon somebody that because you're of a certain age, you can't come to work. The guidelines that I've been seeing and that I've been discussing with clients are 65.
Excellent. You mentioned the implementation task force, and we had a question here that came up about how to safely reopen your retail store. The BRBC, myself, and some of my colleagues throughout the state are actually on that implementation task force, where we're providing some further guidance to elaborate on the initial guidance that was released last week. We did submit our additional details, and there's no one size fits all. I think what you'll see once it's released over the weekend or on Monday is what I'm hearing from DECD, is some sensible steps that people can take. And as you mentioned, Stuart, I just wanted to reiterate that, it's not a one size fits all. And, the additional guidance is really just there to help people, make some sensible decisions that work for their workspaces. So, the general question of how do I safely reopen, I think there's some good sources out there. We'll provide some additional details in the coming days on that website that you shared a link to, which will be included in the slides that we distribute. So that would be, I took one question there off your plate there, Stuart.
Thanks.
But in terms of keeping logs, so the question came in, if someone keeps a log of their clients and there's symptoms to partake in contract tracing, if someone got sick and it was traced back to a particular hair salon or whatever that may be, do you foresee or anticipate that could there be legal action taken against the salon?
So I think if it's a salon or some other business is compliant, right, that they've gotten the self-certification, they're actually doing and maintaining all the things they're supposed to do, I don't really think that's a concern. Will claims be brought? It could be. I mean, we've already seen a claim brought against Walmart for someone who claims they got sick there. I hate to say this, but there may be lawyers that are looking for cases like this. But the fact of the matter is, I don't really see that you're going to be exposing yourself to liability by opening and by adhering to the rules and having the misfortune of somebody who's sick. That's going to happen because of the nature of this virus, is that somebody may come to your salon or to your store who's asymptomatic, discovers 2 days later that they have the virus. I think that's going to be inevitable. Hopefully, though, if people are adhering to the social distancing and to the, the hand washing and everything and wearing masks, that it's not going to have the result of creating a cluster in your store or your salon. I read another article last night by a physician about, how the masks are really, really effective, and they don't have to be N95 masks. If people really wear, any of these masks that have been made commercially available or make it yourself mask, it's really makes a huge difference. So, you have to hope that people are going to adhere to that. I don't know how easy it is to cut someone's hair if the person's wearing a mask, but that's what's contemplated. So, I think there is, I would say there's a risk of claims being brought, but it just does not seem that would be a successful, allegation of liability against a business owner who has done everything they were supposed to do. I would encourage people, check with your insurance professionals. I'm sure they're getting these questions also. But, I don't think that's, that would, if we had that concern, that would really have a chilling effect on anybody reopening. And I don't think that's what's intended.
Right. Yeah. Further to that, what documentation do you think can you give as a suggestion for employers when an employee thinks they've been exposed to someone with COVID? They say they can't return to work because of that exposure. I mean, how many times can they go about, say they've been exposed and continue to stay out of the office and when they're looking to get back?
I mean, there's going to be some people who look to take advantage. That's always the case. it's a little tricky asking for documentation just because sometimes you can't even get it, right? Even if it's legitimate. You know, as a legal matter, right? If I say that I've been exposed and you know, then I am entitled to the emergency paid sick leave. I'm only entitled to it for 2 weeks, you know, separate and apart from any other sick leave that I might have. So I really can't stay out indefinitely and expect to be paid. You know, that's just, you know, it's like any other person who would use paid sick leave. So, you know, there are going to be kind of those limitations. People aren't going to, you don't get to stay on unemployment, for example, because you've been exposed. That's not how unemployment works. So I do think it's fair to ask for documentation. You know, somebody may or may not be able to provide a doctor's note. You know, let's say I have a close family member, a spouse or a child who, you know, who's sick and I'm caring for that person. If I can get a note from that provider to share with my employer, I should do that. If the employer asks and doesn't get documentation, well, the employer should make note, you know, on such and such date, Stuart said his son had this, and, you know, just to keep track of it. And if there's a pattern that, you know, sort of belies reality, you know, employers are going to have to make some difficult decisions here. And, you know, I think that's inevitable. Hopefully there's not going to be an abundance of that.
Right. Thank you. I know we're at 10 after. Do you have time for one more?
Yeah, sure.
Excellent. And then what we'll do is like I said, we'll capture all these questions for everybody else and respond back. You know, we'll get them to Stuart and he can appropriately respond, and we'll get them back to everybody. But this one's come up a few times too. So through contact tracing, an employer identifies an employee who may have been exposed. Can they force them to go home for the day?
If you have someone who's been exposed, who's asymptomatic or symptomatic, I think you can. You know, I think there's no mandate necessarily, but, you know, it depends on the nature of the exposure, right? If I share a desk with somebody and that coworker is sick, well, regardless of whether I show any symptoms, I should be sent home, you know, just to monitor symptoms. You know, if it's, you know, the coworker of mine who I may or may not have passed in the hall, or we may use the same lunchroom, but I don't remember seeing him. You know, that's not as obvious a call. And I think employers are going to have to use some discretion there.
Got it. All right, great. Well, I appreciate your time, Stuart. I think this was very valuable information you shared. Like I said to everyone, you know, we'll share the questions that we didn't get to. There are quite a few here. But if, you know, to respect everyone's time, you know, I know we've already taken over an hour of Stuart's time and everyone else's here. So I appreciate everyone for joining us. Stuart, I thank you again and the folks at Cohen and Wolf for everything you've done, not just for us at the BRBC, but for the general business community at large. And again, for your time today, sharing this really valuable information. So with that, I appreciate everyone's time, and please be well, be safe. As Stuart suggested earlier, if you're able to work from home and still being able to do so, stay home if you can. Let's do our part to help get this first phase rolled out with minimal impact on the virus increasing, symptoms increasing, and cases increasing. Because the worst thing that we can do is have some kind of rollback where we have to shut things down again. That would not be good. So be well, everyone, again, and we'll talk soon. If you have any questions, please feel free to call the BRBC at 203-335-3800. You guys know where to reach us online as well. So be well, everyone. Thanks again, Stuart. I appreciate it.
Thanks, Dan.
Yeah, you got it.